February 2023. Things look like they are getting underway in court today. Let's listen in.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Welcome to all the lawyers, and good morning to Mr. Walsh. Before we get started with today, I'll see you at the side of the bench.
60s and 70s sound real good right about now. That's the 60s and 70s down in the sort of mid-south as of right now. Dallas at 72 degrees, 68 degrees for our friends down in Arkansas and Little Rock there, but 30s north of the Mason-Dixon line and even some 20s as well. That's how we're waking up on this Tuesday morning, everybody. Feels like the upper 20s and even lower 30s in the city of Boston and surrounding area, especially Metro West right now, feeling like about 29 to 30 degrees. We were in the lower 40s yesterday, so we had a few more clouds that kind of drug along into the early afternoon and allow temperatures to be significantly below average, about 6 to 7 degrees. In fact, we're going to be averaging around 5 degrees below average again later today. We should be around 51 degrees for this time of year. My forecast high for Boston, 46. Okay, and but definitely going to be breezy, not as breezy as what we were dealing with here yesterday, but gusty anywhere between 15 and 20, maybe gusting around 25 miles per hour. So it'll likely feel like the mid to upper 30s again later on today. We have improving conditions as we end the work week and we head towards the weekend. We're down to about a 20% chance of some spot showers there for Friday. Most of those showers are actually going to be confined to areas south and also areas north, and Boston's going to be right in between. So we're going to be back dry for the upcoming weekend, Saturday and Sunday, upper 40s, 47 to 48 degrees both Saturday and Sunday. This is a system that we're watching on Friday. Notice the clock there at the top right of your screen. That cold front will move eastbound across the Commonwealth and perhaps even spray the region with a couple spot showers. Some areas south maybe get a spot shower or two along the south coast, perhaps even the island of Nantucket, and maybe up into the Merrimack Valley and maybe the lakes and mountains maybe get a couple spot showers there, and maybe a few flakes will squeeze out of that as well. Obviously, the high terrain has colder temperatures and any sort of moisture will likely be able to freeze on contact. High pressure moves back in thereafter, so we get rid of that system. That allows for a lot of stable conditions for Saturday and also on Sunday as well, which is why we're going to be having a mainly dry upcoming weekend. The next few days we'll have a lot of sunshine today, a lot of sunshine tomorrow. Thursday will likely throw a few extra clouds our way. We actually have some low level and also some mid-level clouds coming in, clashing right across southern New England. So we'll have dominant cloud cover for the future for us on Thursday and likely on Friday as well. The only difference will be the temperatures on Thursday and Friday. More of the milder temperatures, low 50s arriving for us on Friday as well. So if you're looking for a day to get out and do a little bit of lawn work, maybe a couple days to rake, Thursday and Friday will be the best bet. We'll have lighter winds both those days. Mainly quiet again today. Sunset later on today will be around 4:19 p.m., 4:11, and early December on December 8th there. And then we start to kind of dial up a little bit more sunshine day by day going through spring of next year. We'll still be around the mid to lower 40s again across the board there, at least for tomorrow. Long-term outlook, though, the next 6 to 8 days, next 6 to 10 days coming from the climate prediction center.
Mr. Walsh, do you wish to offer a change of plea on docket number 2382CR91002, which charges you with intimidation of a witness, juror, police, or court official, and 003, disinterment of a body? Do you wish to offer a change of plea from not guilty to guilty?
I do.
Could you raise your right hand, please? Do you solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God?
I do.
Thank you. Could you please take the witness stand?
Actually, you know what I'm going to, this is an odd configuration. I don't want counsel standing. So I'm going to let you stay right there, sir. You understand you're under oath?
I do.
All right. Why don't you be seated and you can have the benefit of your counsel at the ready right there.
Okay.
Mr. Walsh, as you know, my name is Diane Frenier. I'm the judge that's presiding over this trial, and I'm an Associate Justice of the Superior Court in Massachusetts. I understand from your lawyers that you wish to change your plea to guilty to counts indictment 002 and in 003. And before I can accept that change of plea to guilty to those two indictments, I need to ask you some questions to make sure that your decision to plead guilty is made voluntarily and that you understand the consequences of pleading guilty to those two offenses. If at any time during the course of this colloquy you don't understand something that I am saying to you, just let me know by letting your attorneys know. Let them consult with you. And equally, if I don't understand something that you're saying to me, I'll ask for that further clarification. Do you understand, sir?
Yes, Your Honor.
All right. Can you please state your full name, sir?
Brian Walsh.
All right. And Mr. Walsh, do you have any difficulty speaking or understanding English?
I do not, Your Honor.
How old are you, sir?
I'm sorry, I missed that.
Sure, I'll try to get into this microphone. How old are you?
50.
And what's your exact date of birth?
January 31st, 1975.
Where were you born, sir?
Boston.
Are you married?
Yes.
Do you have any children?
Yes.
And what are their ages?
9, 6, and next month, Brian will be 5.
How far did you go in school?
College, some college.
And that was like a year and a half or 2 years.
Oh, yes.
And where did you go to school?
Carnegie Mellon,
What did you study?
business and computer science.
As an adult, have you had full-time employment?
I've had my own businesses,
And in what kind of businesses?
mostly consulting.
Okay. I need to ask you some personal questions. I'm going to ask you those questions now. Have you ever in the past been treated for any mental illnesses or conditions?
Yes.
Tell me about them.
Depression.
And are you aware of whether anything else other than depression?
That was the main thing.
All right. And are you presently aware of whether you have any mental illnesses or conditions, to include depression?
No.
Are you taking any medications?
No.
In the last 24 hours, have you taken any drugs, legal or illegal?
No.
In the last 24 hours, have you consumed any alcohol or alcoholic beverages?
No.
Is your mind clear here today?
Yes.
Tell me in your own words, sir, why are you here
I'm here to plead guilty.
on those 2 counts?
Yes.
And you understand that your trial's starting today?
Yes.
On the first indictment? All right. To defense counsel, have you had any difficulty communicating with your client?
No, Your Honor.
And do you believe that he has understood the advice that you've provided to him?
Yes, you do.
Same.
So at this time, I'm going to go over what's called the waiver of rights. And at the end of it, I'm going to give you the form back that I believe you signed earlier today. Do you understand, sir, that by pleading guilty that you're giving up your right to have a public, fair, and impartial trial as to each of the 2 indictments to which you're now pleading guilty, with or without a jury, to determine your guilt or innocence?
I do, Your Honor.
And do you understand that if you went to trial, you wouldn't have to prove anything? For example, you never have to take the stand to testify. You would never have to call any witnesses. No jury could ever hold it against you if you did not present any evidence at all. Instead, it is the Commonwealth that has the burden to prove you are guilty of each of the offenses and each element of those offenses beyond a reasonable doubt. Do you understand that?
I understand, yes.
You have the right to be tried by a jury of 12 people selected from your community, and you would have the right to participate in jury selection. You could not be found guilty unless the Commonwealth convinces all 12 jurors that you are guilty beyond a reasonable doubt, and they unanimously agree you are guilty. Do you understand?
Yes, Your Honor.
You also have the right to be tried by a judge instead of a jury. And again, the judge couldn't find you guilty unless the Commonwealth presented evidence sufficient to convince the judge beyond a reasonable doubt that you are guilty of the charge. Do you understand?
Yes.
Do you understand that if you went to trial, you would have the right to confront your accusers and any other witnesses that may testify against you by facing them and having your attorneys ask questions of them?
Yes, Your Honor.
And do you understand that if you went to trial, you would have the right to call your own witnesses, present your own evidence, and if you wished, even testify on your own behalf? Do you understand that?
Yes, Your Honor.
Do you understand that by pleading guilty here today, you're giving up your right to pursue any arguments or motions that your attorneys may have made or filed on your behalf in this case, and that may include motions to dismiss and motions to suppress, as well as your right to appeal any rulings or decisions that the court may have already made in this case?
Yes, Your Honor.
And are you willing to give up each of those rights?
Yes, Your Honor.
Pass that to the defendant. Sir, if had the court officer pass to you defendant's waiver of rights, have you seen that form before?
Yes, Your Honor.
And did you read that document or have someone read it to you?
Yes, Your Honor, I read it.
Have you reviewed it with your attorneys? Do you understand it? Do you understand what's contained on the waiver of rights form?
I do, Your Honor.
You understand that that form sets forth in writing what you and I have just been discussing a moment ago in terms of your willingness to waive your constitutional and statutory rights and plead guilty to the two indictments.
Yes, Your Honor.
Is that your signature at the end of the document?
Yes, Your Honor.
And did you sign that voluntarily?
Yes, Your Honor, I have signed it voluntarily.
By signing that form, you're confirming to me, sir, in writing that you are aware of the rights explained on the form, that you understand them, and that you voluntarily waive them. Is that correct?
Yes.
Do you understand, sir, that you are pleading guilty to the following two indictments? Indictment 002, which charges willfully misleading a police investigation, a criminal investigation, in violation of Massachusetts General Laws, Chapter 268, Section 13B, and in Indictment 003, you are pleading guilty to, while not being lawfully authorized by proper authorities, willfully conveying away a human body or the remains thereof in violation of Massachusetts General Laws, Chapter 272, Section 71. Do you understand that?
Yes, Your Honor.
And have you talked to your attorneys about each of these two indictments?
Yes, Your Honor.
Has counsel explained the elements of each of those two indictments that the Commonwealth would have to prove beyond a reasonable doubt?
Yes, Your Honor.
Do you understand each indictment?
I'm sorry, what did you?
Do you understand each indictment?
Yes, Your Honor.
And to defense counsel, have you explained the elements of each of the two offenses to your client?
Yes, Your Honor.
I'm going to ask that the assistant of the Commonwealth, whoever wishes to do it, would tell me what the maximum and minimum sentences are. And I don't believe there are any mandatory minimum sentences, but you can tell me if there are.
There are no mandatory minimum sentences, Your Honor. The maximum sentence on count 2 is 10 years unless the investigation is into a capital offense, and then it is a 20-year sentencing enhancement, up to 20 years. On count 3, it is up to 3 years in state prison.
Thank you. Mr. Walshe, did you hear the maximum possible sentences for the charges that the Commonwealth just recited?
Yes, Your Honor.
And do you understand those maximum potential offense charges, sentences?
Yes, Your Honor.
Do you understand that I have the authority to impose consecutive sentences on indictments, meaning, for example, that the sentence on the second indictment would begin only after you completed your sentence on the first indictment?
Yes, Your Honor.
Do you understand that if I impose a period of probation, you will be subject to the terms and conditions imposed, including not committing any other crimes and reporting to your probation officer?
Yes, Your Honor.
If you should later be found in violation of any of the terms or conditions of your probation, a judge could sentence you up to the maximum penalty allowable by law for any of the charges on which you have been found in violation of probation, and would be required to sentence you to any mandatory minimum penalty required by the law.
Yes, Your Honor.
Do you understand what I just explained?
Yes.
Pleading guilty has certain implications for you, and I'm going to go over those implications with you now. First is DNA testing. By pleading guilty to these two indictments, you will be required by law to submit a sample of your blood, hair, and/or saliva, and that sample will become part of the Massachusetts DNA database. You will be required to pay for the cost of collecting, preparing, and processing that sample unless you are determined to be indigent, and failure to comply with this law will subject you to separate criminal penalties. Do you understand?
Yes, Your Honor.
Are you still willing to plead guilty?
Yes, Your Honor.
I know earlier in the colloquy this morning you told me that you were born in Boston, and I have no reason to doubt that. But the law mandates that I give you warnings with regard to immigration consequences, and I'm going to give you those immigration consequences now. If you are not a citizen of the United States, you are hereby advised that my acceptance of your guilty plea may have the consequence of deportation, exclusion from admission to the United States, and denial of your naturalization request, all pursuant to the federal laws. Further, if the offense to which you are pleading guilty is under federal law, one that presumptively mandates removal from the United States, and federal officials seek your removal, it's practically inevitable that this conviction will result in deportation, exclusion from admission to the United States, and/or denial of your naturalization request, again, under those federal laws. Do you understand what I just said?
Yes.
Has your attorney advised you of these consequences if you are not a citizen of the United States?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
Because the sentence for count number 2 could be a sentence, a state prison sentence of 3 or more years, I'm now going to give you what's called the habitual offender law warning, which I'm required to give you. Here it is. If at some time in the future you are convicted or plead guilty to a third or subsequent offense that is within the category of offenses covered by the statute, then 1, you may be imprisoned in state prison for the maximum term provided by law for such third or subsequent offense. 2, your sentence could not be reduced or suspended. And 3, you may be ineligible for probation, parole, work release, or furlough, or to receive any deduction in the sentence for good conduct. Do you understand what I just said?
Yes, Your Honor.
And understanding what I've advised you with regard to these sentencing consequences, are you still willing to plead guilty to the 2 charges?
Yes, Your Honor.
All right. I'm now going to ask the Assistant District Attorney to summarize the evidence that would have been presented against you by the Commonwealth if you went to trial in this case. And I'm going to ask, sir, that you listen carefully, because when the ADA is finished, I'm going to ask you some questions about the facts that the ADA has stated.
Thank you, Your Honor. Your Honor, regarding count 002, misleading police in violation of Mass General Laws, Chapter 268, Section 13B. On or about or in between January 1st to January 8th, 2023, Mr. Walsh did willfully mislead police officers with the intent to impede, obstruct, delay, prevent, and otherwise interfere with the criminal investigation into the disappearance and murder of Anna Walsh. The defendant first misled with Cohasset police in the morning of January 4th, 2023, when after he had reported his wife Anna Walsh missing, he stated to a Cohasset police officer that Anna Walsh had left the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset on the morning of January 1st, 2023, by taking an Uber or Lyft to Logan Airport when returning to Washington, D.C. for a work emergency. The defendant then continued to mislead police officers when he made additional false statements about Anna Walsh being alive and voluntarily leaving the Walsh residence, as well as when he detailed his whereabouts on January 1st, 2023, to Cohasset police and Massachusetts State police officers. The defendant continued to make false statements when the police officers from these agencies met with him, including on the evening of January 4th, on January 5th, January 7th, and January 8th. In January of 2023, the Cohasset Police Department had approximately 20 full-time police officers, including 2 detectives. The Cohasset Police devoted all available resources in an attempt to find Anna Walsh. They requested assistance from other departments and agencies. And on January 6th, the Chief of the Cohasset Police Department conducted a press conference seeking help in locating Anna Walsh. As a result of the defendant's false and misleading statements, law enforcement agencies and police officers took many actions, which had a heavy financial and emotional cost. These included the Cohasset Fire Department searching a swimming pool at the Walsh residence, teams of police officers from multiple agencies and departments, including a K-9 teams participating in large-scale canvass of the area around the Walsh residence during inclement weather. DC Metro Police attempted to locate Anna Walsh in Washington, D.C., and Massachusetts police officers, including Cohasset Police, Massachusetts State Police detectives, and other units from the Massachusetts State Police traveled to Washington to search for Anna Walsh in a result of the defendant's false statements. The defendant's conduct was willful. His statements impeded, obstructed, delayed, and otherwise interfered with the criminal investigation, and the delays resulted in contents of dumpsters in which the defendant had disposed of Anna Walsh's remains being incinerated.
Why don't you pause there? We'll deal with count one and, count two, and then we'll go to count three.
Yes, Your Honor.
All right. So, Mr. Walsh, did you hear what the Assistant District Attorney just said with regard to the statement of the offense conduct for indictment 002, misleading police?
Your Honor, if I may, Mr. Walsh is prepared to admit to the recitation of facts with respect to the indictment that the government just read, insofar as it alleges he did impede and obstruct the criminal investigation into the disappearance of Anna Walsh. We obviously object, and he's not admitting to and murder. The second portion of the facts that the government just read that we would take issue with is the last sentence, and the delays resulted in the contents of the dumpsters into which the defendant had deposited Anna Walsh remains being incinerated. Insofar as the rest of the facts, he's prepared to admit.
All right. Mr. Walsh, you just heard what Attorney Porges said, sort of the insofar as. It's another way of saying it limited to this. And you heard what your counsel just said. Understanding those limitations as just articulated by your counsel, did you do or join others in doing those acts?
Yes.
Do you understand that by pleading guilty that you're admitting to the facts described as revised by your counsel are true?
Yes.
Are they?
Yes.
Mr. Walsh, did you in fact willfully mislead various law enforcement to include members of the Cohasset Police Department and the Massachusetts State Police with the intent to impede or interfere with a criminal investigation of Anna Walsh's disappearance?
Yes, Your Honor.
All right. Moving to indictment number 3.
Thank you, Your Honor. Willfully conveying a human body in violation of Mass General Laws, Chapter 272, Section 71. On or about and in between January 1st and January 8th, 2023, the defendant, Brian Walsh, willfully conveyed away the body of Anna Walsh, or the remains thereof, from the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset by conveying and disposing of Anna Walsh's body without a license or lawful authority, or the remains thereof, into dumpsters and or garbage receptacles in eastern Massachusetts. The defendant's actions were willful. Anna Walsh was not a stranger to the defendant. She was the defendant's wife and mother of his 3 young children. The defendant conducted internet searches into disposal of the body, researched locations of dumpsters, and then traveled to those locations. In disposing of the body of Anna Walsh, the defendant did not comply with the law.
Thank you. Sir, did you hear what the Commonwealth just alleged it would prove the case went to trial with regard to indictment number 3?
Yes, Your Honor.
And did you do those things or join others in doing those acts?
Yes, Your Honor.
Do you understand that by pleading guilty to today, you are admitting the facts described just now by ADA Connor?
Yes, Your Honor.
Mr. Walsh, did you in fact willfully remove or convey the body of Anna Walsh or her remains, not being lawfully authorized to do so?
Yes, Your Honor.
Do you now plead guilty to these indictments willingly and voluntarily?
Yes, Your Honor.
Has anyone threatened you or forced you in any way to plead guilty to these 2 indictments?
No, Your Honor.
Has anyone promised you anything in return for your plea of guilty to these 2 indictments other than the terms of the plea agreement that we discussed? Excuse me, there's no plea agreement. That's what happens when you keep reading from the book, and you shouldn't. Has anyone promised you anything in return for your plea of guilty to these 2 indictments?
No, Your Honor.
Have you had enough time to discuss your rights, your case, your defenses, and the possible consequences of your guilty plea with your attorney?
Yes, Your Honor.
And do you feel that Attorney Tipton and Attorney Porges have acted in your best interest, that he and she have fully, fairly, and adequately represented you in this case?
Yes.
Are you confused in any way by any of the questions I've asked you today?
No, Your Honor.
As I understand it then, sir, you're pleading guilty to these 2 indictments because you wish to plead guilty because you are guilty. Is that correct?
That is correct.
Counsel, do you know, defense counsel first, do you know of any reason why I should not accept your client's guilty plea?
We do not, Judge.
Same question to the Commonwealth.
Your Honor, I'll be brief, but we had spoke that this is a non-negotiated plea with the Commonwealth, and we had some objections to it. But my concern was where the defendant equivocates on the factual basis that the Commonwealth read in, that is one reason you should not take it. And the second is this count 3 revolves around the improper disposal of Ms. Walshe's remains. And the defendant, when asked his marriage status, said that he was married. And consequently, Your Honor, then that is not an accurate relaying of his current status to the court and could be invalidating the plea. So I believe he has to be asked that question again. And I believe that if he continues to say he's married, that he's negating facts of count 3.
All right, I'll give defense counsel an opportunity to speak with your client.
Your Honor, I apologize. I couldn't exactly hear what Mr. Connor's caveat was.
In response to one of the early questions I asked of the defendant, I asked him if he was married, and he said yes, he was. And the Commonwealth was raising the point that if that were true, that it might negate proof of the disinterment, which requires a human body or remains. Do you want to speak to your client about that?
A moment, Your Honor.
Mm-hmm.
Respectfully, I don't see this as a relevant or material issue. If the court wants clarification, I'm happy to approach sidebar.
Why don't we do that?
Okay.
So, Mr. Walsh, earlier today I asked you whether you were married, and you answered yes, you were married. Do you remember that?
Yes, Your Honor.
And is it correct that you were married to Anna Walsh for a period of time,
Yes, Your Honor.
and that under the law, death extinguishes marriage? It may not religiously or otherwise, spiritually, but under the law, when someone dies or when someone is dead, you can no longer be married to them. Do you understand that?
Yes.
Yes, Your Honor.
And so are you married today?
Your Honor, if I may, insofar as previous discussions, for purposes of a successful plea colloquy and meeting the elements of the crime, he is acquiescing to the fact that lawfully he is not married today.
All right, you heard what your lawyer just said? Agree with what your lawyer just said?
Yes, Your Honor, I agree.
All right. Anything else that we need to cover?
No, Your Honor.
All right. To the extent that the Commonwealth is objecting to the taking of the plea on other grounds, that is overruled. My job here is to make sure that I have a valid plea, and that means that the defendant is pleading guilty to the elements that the Commonwealth would have to prove beyond a reasonable doubt, and I have inquired sufficiently to assure myself that he has admitted to each of the elements of the two offenses of Indictment 02 and 03.
Right.
We're looking live here at the Dedham Courthouse where the Brian Walsh trial was set to get underway. Paula Eben joined here by Chris Tanaka. The headline this morning, Chris, is that Brian Walsh has changed his plea.
Correct. On two lesser counts, important to note that he has not changed his plea of not guilty to the most serious offense, which is the murder of his wife, Anna Walsh. He has pleaded guilty to lying to investigators and disinterring a body, which basically means moving a body for this purpose.
Right. The judge gave him specific instructions saying DNA testing would now be required. There has been some dispute over him answering the question, are you married? Yes. Let's listen in.
Agreed that we're not going to be sentencing the defendant today on the indictments that he's now pleading guilty to, correct?
That is correct, Your Honor.
Attorney Tipton, Borges? All right. And we'll give the victims a reasonable opportunity to address the court before sentencing, of course.
Thank you, Your Honor.
You understand, Mr. Walsh, that at the time that we do get to sentencing, that by law, I'm not bound to any recommendation that's made by the prosecution or your lawyers. You understand that?
Yes, Your Honor.
And that I may impose any sentence permitted by law up to the maximum allowable sentence.
Yes, Your Honor.
Having considered Mr. Walsh's criminal history, the government's proffered evidence, I will later consider the victim's statements to the court for matters for sentencing. I find that Mr. Walsh has met the requirements to tender a plea to counts 2 and to counts 3. I make the following findings. I find that the defendant is not presently under the influence of drugs or alcohol, and that he hasn't reported that he's not presently suffering from any mental illness or condition, and that he's not presently taking any medications. I find that the defendant understands the nature of the charges and the consequences of his pleading guilty. I find that the defendant's change of plea to guilty with respect to each of the two indictments, 02 and 03, is made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge of its consequences. I find that the defendant's change of plea on these two indictments to guilty is made upon and with the advice of competent counsel, and I find there's a factual basis in the evidence as has been summarized by the prosecution and limited by defense counsel on behalf of the defendant for each of the two indictments to which the defendant now pleads guilty. Accordingly, I accept Mr. Walsh's plea of guilty as to indictments 002 and 003. Anything else that counsel that we need to do on the change of plea?
No, Your Honor.
All right. So let me turn to impanelment. I think you each had an opportunity last night to look at the questionnaire, and I know that defense counsel asked for an additional question to be added. I did add that.
So as you just heard, the judge accepted Brian Walsh's pleas of guilty to 2 lesser charges in his murder case, misleading the investigation and conveying a body. That means basically moving a body post-mortem. Of course, his wife, Anna, her body still missing, Paula, in this murder trial.
Was no doubt significant in the pretrial hearing yesterday on Monday. The prosecutors said they had binders full of electronic materials from a MacBook Pro inside the Walsh home that they plan to present to jurors as evidence. So after yesterday's pretrial hearing, then this change of plea by 50-year-old Brian Walsh. And again, pleading guilty to misleading investigators and conveying a dead body. But the judge did say she would not be sentencing him to anything today.
Correct. And of course, this is day 1 of jury selection, expected to be a lengthy process. The defense wanted to have the trial moved from Norfolk County to Suffolk County because of it. We'll still see what happens there.
And of course, we'll have the very latest. WBZ's Penny Commit is in the courtroom gathering information, and we'll have more for you on WBZ News at noon and continuing on CBS News Boston.
Oh, yes, now I can hear you.
You want to start?
Sure. And you are looking at live images outside of the Dedham Courthouse, where court is in break after Brian Walshe pleaded guilty to 2 lesser charges in the murder case of his wife, Anna. He pleaded guilty to lying to investigators as well as conveying or moving a body. Chris Tanaka alongside Paula Eben welcoming you back as we get ready to speak with WBZ legal analyst Jennifer Roman.
And Chris, before jury selection began, that is when he changed his plea. The judge said he will not be sentenced to those charges today, that he is pleading guilty. We want to turn to attorney Jennifer Roman. Jennifer, I want to make sure you can hear us.
I can, thank you.
Thanks so much for joining us. What's the strategy here?
Yeah, this is a really interesting shift in the defense strategy. It appears that they're hoping that Brian Walshe will be able to plead to a lesser charge than first-degree murder so that he would have the possibility of parole. It's important to note that a defendant cannot plead guilty to first-degree murder, and it's a mandatory sentence of life without parole. So here, where the prosecution doesn't have a body, which is a challenge for them to overcome in this case, if Brian Walshe is taking some responsibility for his involvement, I wouldn't be surprised if there's behind the scenes discussions about whether or not the prosecution will reduce the charge of first-degree murder, which would then allow him to plead guilty and preserve a right of parole for him.
How important is it to have the body when the prosecution, Jennifer, has detailed in their court paperwork mountains of circumstantial evidence starting on January 1st with Google searches, cell phone location of Brian Walshe's older child, surveillance video from Lowe's where Brian is seen buying lots of cleaning devices, I believe in one instance a saw, several tarps. Does the prosecution need the body to prove murder?
They don't need the body to prove murder. Prosecutions have succeeded before on murder charges without ever recovering the body. But it's sort of that final piece in the puzzle that seals this all up for the prosecution. So it is a weakness. It's not an insurmountable weakness, but it does exist. And here, they might want to have a proverbial bird in hand and secure a conviction rather than take the chances at a trial, an expensive and lengthy trial for the Commonwealth, that anything can happen.
So Brian Walshe maintains his innocence on count 1, the murder of Anna Walshe, but by admitting to misleading police and conveying or, moving a dead body, how difficult is that leap to make once you have people on the stand? Do you think he would ever testify?
No, he won't testify. I mean, it's too risky. I mean, he won't testify. He doesn't need to. It's the prosecution's burden. But yes, these charges that he's pleading guilty to, what's the theory of the case going to be? That she died unexpectedly in the home, and rather than call the authorities, he relocated the body. Prosecution says dismembered the body. There was a lot of blood, on carpeting, and her belongings are found in various dumpsters. So why would you go through that effort if somebody just unexpectedly died in your home? So it's not a normal response.
So you're saying he's just trying to preserve the possibility of parole. That's about it at this point?
That's about it. And if there's any chance that the prosecution would agree to him pleading guilty to a second-degree murder charge rather than having to take this to a first-degree murder trial, he wants to try.
Yeah.
He wants to try.
And so from the prosecution side, Jennifer, how much do external factors weigh in on cases like this? Specifically, we've seen this courthouse nationally with the Karen Reed trial, 2 go-arounds. You mentioned lengthy and costly for the state, 2 go-arounds of lengthy and costly Karen Reed trials. Does the Norfolk County District Attorney's Office just want to get, as you said, this bird in hand and secure a high-profile prosecution after 2 recent failures?
Yeah, the Norfolk County DA's office is definitely licking its wounds a little bit after the Karen Reed trial 1 and 2. It garnered so much attention, and that was a real disappointment for the prosecution. So in a case like this, where we've got children who are now motherless and are going, if there's a conviction, they're going to be fatherless too. How much do you try to just help people move on and secure the conviction, rather than try to make a point that it's really first-degree murder? And that's a subjective call that the prosecution needs to make.
Mm-hmm.
Yeah.
And so what do you expect moving forward? Again, the judge had said no sentencing today. They just proceed with jury selection. Will they just continue on knowing these 2 indictments he has pled guilty to? How do they proceed from here?
Right. The jury selection will continue. If the trial goes forward, the judge would likely delay the sentencing on those 2 lesser charges that he's pled guilty to until the time of judgment in the trial. Because if he is in fact convicted of first-degree murder, the pleading guilty to these 2 lesser charges doesn't mean much in terms of a sentence, because he would be convicted. If he was convicted, it's life without parole on the murder charge. If he's acquitted, then there could be some prison time on these 2 lesser charges, which is why I think the judge will defer until the conclusion of the murder trial.
Take us inside the defense attorney's mindset here. What is the most likely, in your expert opinion, charge that they would want to plead into if they were trading with the prosecution?
Well, the defense's best bet would be an involuntary manslaughter charge. I don't know if it doesn't seem like there's the facts to really support that, but maybe that's part of the defense theory, that there was some sort of reckless or wanton conduct that was sort of an involuntary, he didn't premeditate the murder or the killing. That would be their best bet. I think what's more realistic and what's more likely, given the strengths of the Commonwealth's case, is going to be that he pleads to a second-degree murder charge rather than first-degree, which would allow him to preserve his rights to parole.
And after that pretrial hearing yesterday, Jennifer, in which prosecutors said they had the binders full of evidence, do you think either the attorney said to him, we got to talk about this, or this is something they had pre-planned?
I think it was more pre-planned. I don't think anything they're doing is off the cuff. I think this is a very strategic defense team, and they've probably been having these discussions with Brian Walshe for quite some time about what the possibilities are and how they may be able to protect his ability for release and what that might mean. And I think that this plea to these 2 lesser charges is a really strong signal that that's the direction they're going. Let's try to minimize the damage to you, Brian Walshe, because the Commonwealth's case is what it is. Our defense is what it is. What happens next? We never know with a jury of 12 people what can happen. And I think that's a concern for the prosecution, and it's a concern for the defense.
All right, Jennifer, we want you to stay with us. We have to take a quick break, but we have many more questions on the other side of it. We're going to step aside for approximately 2 minutes. We're going to be right back. More questions from Jennifer Roman as court remains in break after Brian Walsh's 2 pleads of guilty.
Yeah, big headline. He has changed his plea this morning. We'll be back with more right after this. Good morning. Paula Eben here with Chris Tanaka. Following breaking news for you this morning, Brian Walshe has changed his plea from not guilty to guilty on 2 charges: misleading a police investigation and conveying a dead body.
Absolutely. Of course, the murder charge still stands as jury selection has gotten underway. We want to bring in WBZ legal analyst Jennifer Roman to clear the air on some of the questions that naturally arise when something like this happens. First things first, Jennifer, what does it mean with these 2 changes of plea?
Yeah, this appears to be a change in strategy on the defense's part, and I think it's a really smart strategy. By having Brian Walshe plead guilty to these lesser 2 charges, it shows that he's assuming some responsibility for his conduct, but also would give them the option or the opportunity to speak with the prosecution about reducing the murder charge to, say, a second-degree murder or maybe even a manslaughter charge, which would allow Brian Walshe to preserve the possibility of parole. A defendant cannot plead guilty first-degree murder. So long as those first-degree murder charges are standing, it would have to go to trial, and there's an automatic right to an appeal after a conviction of first-degree murder. So on one hand, by taking responsibility of these lesser 2 charges, it's not too much of a leap for a jury to think that he actually did commit the murder. But if they can reduce those charges to something less, which would help Brian Walshe on the tail end if he was, if by accepting responsibility, that seems to be what the defense wants to do.
So it's your belief that he's doing this to preserve the possibility of parole, and you had indicated that you think this is probably a strategy they've been talking to Brian Walshe about behind the scenes for some time, considering the fact that the prosecution has amassed so much evidence against him.
Yeah, the prosecution evidence is strong, but they still do have the weakness of not having the actual body. Here, Brian Walshe, by pleading to these lesser charges, is signaling to the prosecution a willingness to accept responsibility, at least for some actions on the night that the prosecution alleges she was murdered. And that responsibility is signaling to the prosecution he wants to talk. And if the prosecution is willing to reduce the charges, I very well expect we would see a plea of guilty to a lesser charge other than first-degree murder.
With those lesser charges, do they carry similar penalties in terms of incarceration time?
On a second-degree murder charge, he could still be sentenced to life in prison. However, he would have the possibility of parole. On a first-degree murder conviction, he does not have the possibility of parole. So a life sentence is truly a life sentence.
Yeah. And of course, there's a lot of strategy that goes into this, not just for the defense, but the prosecution, which for the county has weathered some bad publicity over 2 recent high-profile trials of Karen Reed.
Yeah, it's true, especially since we have Michael Proctor, a factor in this case as well. I mean, is this one of their considerations?
Yeah, the prosecution is definitely, I would think, licking their wounds a bit after the Karen Reed trials. That was a big blow to the Norfolk District Attorney's Office. And while they treat every case differently and they try to assess every case, I can't help but think that that's on their mind. And securing a conviction without the risk of a trial, every trial has a risk. It doesn't matter how strong your case is as a prosecution, there's always a risk that the jury of 12 is not going to see it the way that you want them to. And so for them to secure a conviction of, let's say, a second-degree murder with, the sentence of life, life with the possibility of parole, that might seem pretty appealing to them as the Commonwealth, particularly considering in a first-degree murder case that there's an automatic right to appeal. So this case would not be over even if a conviction was secured. They'd still have to go through the appellate process.
Interesting. So the court of law and court of public perception in this case and many others, 2 very different things.
Very, very different.
Yeah.
And so the jury selection is expected to get underway. Court is in a break at the moment. For those who are not in courtrooms, what happens next?
Sure. So the jurors will come into the courtroom. Every juror has filled out a questionnaire to try to assess at least obvious bias or inability to serve as an impartial juror. or if they have some sort of major scheduling issue. For example, if a woman's pregnant and she's expected to deliver in the next 2 weeks, well, she's not going to be able to sit on the jury. And then the prosecution and the defense both have an opportunity to move to strike a certain number of the jurors. And they do that, assessing sort of what the jurors say on the jury voir dire, where the judge asks a series of questions to understand whether or not that juror can truly be impartial and meet their responsibility of sitting for the length of this trial. And then we start to get jurors impaneled one by one until we have a pool. The target pool is 16, so that we can have 2 alternates and then 2 additional people on the jury. As we saw with Karen Reed, those alternates do become it's likely that they'll become a critical part of the case because things happen and jurors sometimes have to be removed or sometimes cannot fulfill their duty.
Okay, and we just want to reiterate that jury selection is expected to begin soon. Our Penny Commit is covering this trial. She's inside the courtroom. We have word that Walshe has re-entered the courtroom. However, the court's camera feed still not back up.
Right. For the judge, she reiterated that she didn't believe there was any impediment to accepting these 2 pleas from 50-year-old Brian Walshe, Judge Frenier, and again, not sentencing him today. This will wait until the rest of the trial gets underway. That jury selection expected to begin in another few minutes. By accepting some responsibility here, Jennifer, I think a lot of observers at home just watching this trial will wonder, well, if you've admitted to moving a dead body and then misleading investigators, really how much needs to be said once the prosecution gets underway?
Well, it would open up a new theory of the case for the defense team. I mean, the defense could argue that there was an unexpected death, that Anna Walshe, maybe she mixed, maybe it was New Year's Eve, so maybe she drank too much and mixed it with some prescription medications, which had an unexpected result. I think they're going to shift. They're going to shift it to she died unexpectedly, he panicked, and this is what he did. Whether or not that's going to work, I think, depends on how the other evidence comes in from the prosecution. And it doesn't address those Google searches that Brian Walshe is alleged to have made about how long before a body decomposes, how to dispose of a body. Those are really damning searches for him. And so it becomes this question of, can the defense say, well, no, that was part of his panic. Right? She died unexpectedly. He didn't know what to do. He was trying to assess his options. Is that plausible to a jury, or does that not sit with them as a plausible explanation?
Yeah. Hey, Jennifer, as lay people, we sit here and we watch these courtroom proceedings, and when there's a change of plea, it naturally perks up our ears. But you have used the terms smart, strategic. How surprising or unsurprising is this to you?
I do think that this did come as a surprise, but I think if my theory is right, that this is part of a larger strategy to try to preserve the possibility of parole for Brian Walshe. I know that his defense team wouldn't have done this unless they really thought it could potentially be helpful to him. They're not going to do anything that could potentially hurt him in the long run. And so what would not surprise me now that we've seen this plea deal come through on these 2 lesser charges is that there is a discussion ongoing with the prosecution about potentially accepting a plea deal on a lower charge than first-degree murder.
Jury selection is such an art, not really a science, Jennifer, but in your experience, obviously you always want to select people who make clear-cut decisions, usually who have careers where precise thinking is involved. What kind of a juror would you be looking for if you were on his defense team?
If I'm on the defense team, I'm trying to stay away from those stay-at-home moms or a stay-at-home parent who is the primary caregiver for their children. I'm probably looking for somebody who may be divorced, because part of this defense theory so far has been marital troubles doesn't equate murder. And so I'm looking for somebody who might have some empathy and insight into that, hey, maybe your marriage doesn't work out, but it doesn't mean you have so much ill will or hatred towards somebody that you're actually going to kill them. So those are the kinds of people that I'm looking for. I'm also looking for somebody who might be skeptical of law enforcement. So I don't want anybody who has family or extended family that's in law enforcement. I want somebody who could really look at this case and decide whether or not the police and the investigators did a thorough investigation, as opposed to jumping to conclusions that Brian Walshe was the only possible perpetrator, because I think that's also going to be part of the defense theory, is that there was a rush to judgment here.
Yeah, and without being insincere towards the family of Anna Walshe, when we talk about this case, in the absence of a body, how does the prosecution get this over the finish line?
Right. The prosecution's going to have to be really methodical and really weave this story together for the jurors. And they're going to start with every little bit of circumstantial evidence that they have. And they have a lot of it. And there's also some direct evidence that suggests that Brian Walshe was involved in some way with with her death. And we sort of wonder, how much does that admitting to just obstructing justice and obstructing the police investigation and moving the body plays into some of that circumstantial evidence that the prosecution's going to rely heavily on. Prosecution's going to rely on those surveillance photos and video from Home Depot where he's seen buying cleaning supplies and a hacksaw and bleach and goggles and gloves and tape. All of these things that we think, why is somebody buying that? That's craziness. Why were they buying that, particularly on a night when his wife goes missing, or a few days later? And so the defense knows the prosecution's going to rely heavily on that. So in another strategy position, possibly, the defense is saying, if we can negate that, if we can say, yeah, he bought those things because he panicked, as opposed to he bought those things because he murdered her and then was trying to dispose of the body, they've somehow taken some of the wind out of the prosecution's sails. So the prosecution's going to have to try really hard to weave all of these bits and pieces of circumstantial evidence and some of the direct evidence. There was Anna and Brian Walshe's DNA inside his vehicle. So is there an explanation for that? We don't necessarily know how long DNA has been sitting there in a car, or anywhere for that matter. So they're really going to have to sort of walk the jury through their theory of the case and tighten up some of those potentially loose ends to say that he actually did this. Right. And I think they can be successful in that if they do it carefully and if the evidence comes in the way that we're expecting it to come in. But then we've also got the defense who's going to have that opportunity to poke holes and to challenge the theory of the prosecution and really, hang their hat on, we don't have a body. And we have, a married man who has children with this woman who panicked, and he's taken responsibility through the pleads for the pleas that he did today for his part, but that's where his part ends. And so this is going to be really interesting if this does proceed, as how these parts play out.
And we understand from our Penny Commit, who's in the courtroom, that his mother is back in the courtroom. She has some involvement here that will be part of the prosecution and the defense. I know the judge had talked about having the jurors not watch any news during a trial. Whenever I hear something like that, I think, how hard is that to enforce and expect? We expect the jurors, they take an oath that they are going to follow the court's orders, that they're going to deliver justice. They're going to hear the evidence as impartially as they can and weigh all the evidence and make a decision based upon the evidence. And so we ask jurors in many cases not, especially cases that have this kind of media coverage, to not access social media, to not talk to people about this case. I mean, we give that instruction in general. Don't talk to family members or friends about your role as a juror and what you're doing in this case, because we want to protect the integrity of the juror mindset and that they are to hear things impartially. And I would say that people honor it. And if they don't, we tend to find out about it, as we did with Karen Reed's case. She had a juror excused because they acknowledged that they had, been talking and reading newspaper reports about the trial. And so every day of the trial, the judge is going to ask the juror, have you spoken to anybody? Have you read anything? And the jurors, in my experience, are honest about that. And so we typically do find out about it.
Yeah. And just to refresh people on the backstory and the timeline of this, Brian and Anna Walshe hosted a New Year's Eve party at their home December 31st, 2022. She told him, according to him, he said that she said she had to fly to Washington, D.C. for a work trip early January 1st. That, according to investigators, was the last time she was seen, but it was almost a week before Cohasset police put out a notice for a missing woman. I believe it was January 6th when they finally did that. Is there anything about that gap in 5 days that's unusual in a missing persons case? Jennifer?
Well, a person can't go missing until someone reports them as missing. And here it took, I think it was until January 4th for Anna's employer to say she didn't show up for work when she was expected to. So it's not unusual to have a longer period of time between somebody going missing or logically having, being last seen and actually getting reported to the police, particularly for an adult. It's not for a child. We would jump on this much more quickly. Presumably, a parent or a friend or a school would notice. But for an adult, it's not that uncommon. But that 5-6 day delay doesn't help the prosecution, right? And we see that. That's why they're missing some evidence that, the prosecution's theory is that he disposed of her body in dumpsters and that those dumpsters, just by regular trash pickup, were taken and incinerated. So evidence was lost as a result of that delay. And that is what we find happens. The longer the delay, the more likely it is that evidence is going to be compromised, as it appears to have been here.
For any viewers that might be joining us here at a quarter before the top of the hour, the headline this morning is that Brian Walshe has changed his plea from not guilty to guilty on the two lesser charges, misleading a police investigation and conveying a dead body. Question for you, Jennifer. Why can't someone plead guilty to first-degree murder?
It's statutory. So our law says that when you have the possibility of a life sentence without parole, you are not allowed to plead guilty to that, and you are entitled to an automatic appeal. So it is written into our laws that way.
Fascinating. But as you had mentioned earlier, the possibility now of further plea agreements between the defense and prosecution, which were really wedged open, if you will, by the guilty plea on these two lesser charges, correct?
Yes, for sure.
Yeah. Interesting.
So at this point, the lesser charge will mean the possibility of parole for Brian Walshe. That is sort of, it seems, the strategy that is the one thing he can hold on to if the prosecution has so much evidence. And Jennifer, as jury selection gets underway, in this case, compared to others, about how long do you estimate jury selection will take?
I think we're going to see a longer jury empanelment than what we would typically see in a murder case, given the high-profile nature of this crime, given the actual nature of the allegations, even that she was a mother, they were married. I mean, that touches a lot of emotional spots for people. And so both sides are going to want to be really careful about impaneling a jury that can truly be unbiased and impartial in this case. So I think it wouldn't be unexpected to have a 2-week jury empanelment for this case. With the goal is to get 16 potential jurors so that there can be 12 on the jury, 2 alternates, and then 2 backups to those alternates.
And of course, if and when the trial does begin, it's expected to be lengthy. It's expected to be costly, potentially up to 100 witnesses called to testify. What's the strategy with having so many witnesses?
Yeah, I think that is part of the prosecution's methodical piecing together of these puzzle pieces. Yeah. I think it appears that a lot of people have touched some part of this case. So we're going to see a lot of experts. Right, we're going to see experts who analyzed the blood on the carpet that the prosecution alleges was removed from the Walshe home during their investigation. We're going to have another expert who can talk about the bone fragment that was found in one of the dumpsters. We're going to have people who talk about the personal belongings having belonged to Anna Walshe, her purse, her necklace that she was known to wear, a pair of hunter boots, her COVID vaccine card, all of those little things. We need different people to place on Anna's person and to say, yes, that is a necklace that she typically wore. That was the purse that she typically carried, or that I've seen her carry on multiple occasions. So all of that sort of circumstantial evidence requires different people to touch it and to explain it. We're probably also going to hear testimony from her employer and maybe fellow coworkers about what kind of employee she was, what kind of colleague she was, because the prosecution wants to debunk any theory that she would have just up and left her children, or that she was somehow unreliable, or maybe was suffering from some type of addiction issues or something. Anything that the defense could possibly rely on to try to poke holes in the prosecution's case. The prosecution's going to want to get ahead of that, and that's going to require several witnesses. So we have a lot of people, and then we've got the defense witness.
Okay, Jennifer, we're going to interrupt you quickly because the judge is back in court.
I'm going to ask you questions as a group by a written questionnaire. And then the lawyers and I will speak to you separately, one by one, in this courtroom. You'll be seated in the witness stand. And I will ask you questions. And then the lawyers, as you know from the video, play their own important role.
Inside the Norfolk County Courthouse in Dedham. Slight freeze there on the video, so we'll try and address that and get back to it. But some fascinating insight from WBZ legal analyst Jennifer Roman as Brian Walshe pleads guilty to 2 lesser charges in his murder case against his wife, Anna Walshe, lying to investigators and conveying a body, which means moving a body post-mortem.
And reading the tea leaves on this, Jennifer has been saying that because you cannot plead guilty to first-degree murder in the state, and that would go right to the appeals process, the best hope for him, Jennifer, at this point is that this would preserve the possibility of parole?
Yeah, I think the strategy here from the defense is take responsibility for these lesser offenses, show the prosecution that you're willing to accept responsibility, and hope to negotiate a lesser charge of the murder. So rather than first-degree murder, try to secure an agreement from the prosecution that they'll accept a plea deal from him for second-degree murder, which would give him, although it would still be life in prison, the possibility of parole, which he does not have under the current first-degree charges.
All right, interesting stuff there. And of course, the court will keep going with jury selection until interrupted, correct?
Yes.
All right, let's listen in once again. We've got that courtroom feed.
Alleges on January 4th, 2023, Anna's employer called police to report that she was missing. Cohasset police went to the Walshe home where the defendant reported that Anna was missing and alleged that she had left the house early the morning on January 1st and that he had not heard from her since then. Days later, police searched a dumpster outside the defendant's mother's Swampscott apartment and found clothing that belonged to Anna Walshe, Anna Walshe's COVID vaccination card, towels with red-brown stains, a hatchet, and a hacksaw. The defendant is charged with murdering Anna Walshe. The defendant denies these allegations, is presumed innocent, and has pleaded not guilty. I will now ask the lawyers to introduce themselves and to tell you who they represent. We'll start first with the Commonwealth. ADA Connor.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Greg Connor. I'm an Assistant District Attorney for the Norfolk District Attorney's Office, and I will be representing the Commonwealth along with...
Good morning, ladies and gentlemen. My name is Tracy Cusick. I'm also an Assistant District Attorney at the Norfolk County District Attorney's Office. And I'm also an assistant district attorney, and my name is Ann Yaz, and I will also be representing the Commonwealth.
And for the defendant, Mr. Walsh, Attorney Tipton.
Good morning. My name is Larry Tipton. I represent Mr. Walsh.
Good morning, ladies and gentlemen. My name is Kelly Porges, and I'm also here on behalf of Mr. Walsh.
Good morning.
Thank you. Let me talk a little bit about the trial for the schedule. The schedule for the trial, try it that way. Today, as you know, is Tuesday, November the 18th. We plan to select the jury before Thanksgiving, and we will start the trial itself on Monday, December the 1st, 2025. The lawyers estimate that it will take between 3 to 4 weeks to try this case and to present all the evidence. The jury will then meet to discuss and consider the evidence and issues in the case, and we call that deliberation, to reach a decision, which we call a verdict. There is no set time for a jury to decide a case. The jury takes as much time as it needs to unanimously decide the case. During the trial, while the evidence is being presented, our typical daily schedule will be between the hours of 9 a.m. and 4 p.m. We take a morning break at 11 a.m. and a lunch break between the hours of 1 and 2 p.m. There may be a day here or there, typically on a Friday, that we might suspend early depending on the pace of the case. When the jury begins its deliberations, the jury will deliberate from the period of 9 a.m. to 4:30 p.m. And again, we set no pace for the deliberations. The jury takes the time it needs to decide its case. Before we begin selecting jurors, I want to briefly explain some important legal rules that the jury must follow. And at the end of the trial, I'll give you more detailed instructions on the legal rules that apply in this case. Let me start by teaching you about the presumption of innocence and proof beyond a reasonable doubt. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walsh is presumed innocent of the charge in this case. That means the jury must consider Mr. Walsh to be innocent at the beginning of the trial and must still consider him to be innocent at the end of the trial, unless the prosecution proves beyond a reasonable doubt through evidence presented during the trial that Mr. Walsh committed the crime charged. The fact that the Commonwealth has charged Mr. Walsh with this crime through an indictment and that he is now standing trial is not evidence. And it's not relevant to whether the defendant is guilty or he is not. An indictment is not evidence whatsoever that the defendant is guilty of any crime. An indictment is merely a formal accusation that the defendant may have committed a crime in order that he or she may be brought to court for a trial before a judge and a jury. It is that jury that is to be selected from among your number, and that jury alone, which must decide whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the offense that has been alleged. Again, based on the evidence and the law that is presented during the trial of this case. The defendant does not need to do anything to convince you that he is innocent. He doesn't have to explain anything to the jury. He doesn't have to testify, call or question any witnesses, or provide any evidence at all, because you must presume he is innocent. Instead, the Commonwealth has to prove the charge against Mr. Walsh beyond a reasonable doubt. If you serve on this jury at the end of the trial, you may not find the defendant guilty of the crime charged unless the prosecution convinces you beyond a reasonable doubt that Mr. Walsh committed that crime. If you are left with a reasonable doubt of Mr. Walsh's guilt, on the charge, then your verdict must be not guilty on the charge. Now let me turn to some important rules that you must follow during our jury selection process, and in fact, until your jury service is over. It's important that you keep an open mind about this case. Do not discuss this case or the questions we ask during our jury selection process with any other potential juror or with anyone else. Do not send any electronic communications or posts. In fact, you should be well informed by now that your phones should be off. And if they're not, make sure they are. Do not look up anything on any device to include your phone. Don't do any research about jury selection or about the case or the people involved in the case. If you are chosen to serve on the jury, you may tell people that you are serving on a jury here in Norfolk Superior Court, and you may give them the trial schedule and how long your jury service is likely to last. But you must not tell them anything else about the case until the trial is over and the jury has reached its verdict. Let me next talk about the jury selection process. When the lawyers and I ask you questions, and many of them are going to come in a written questionnaire, but then you'll come back into the courtroom and have individual questions asked of you. We're not trying to pry or make you feel uncomfortable. Instead, we ask you these questions to determine whether you're able to serve as that fair and impartial juror, whether you have a reason to favor one side or the other, and whether you're confident that you can decide this case based only on the evidence that will be presented during the trial and the legal instructions I teach to you. It's very important that those of you who are chosen to serve on this jury be able to commit yourselves to deciding this case, again, based only on the evidence you hear or see in this courtroom, and not on anything else, such as your personal experiences or the experiences of someone that's close to you that you might know about. It's also very important that those of you who serve on this jury not allow the nature of the allegations in this case to make you lose sight of the question that the jury must decide, which is whether the Commonwealth has or has not proved beyond a reasonable doubt that the defendant committed the crime charged in this case. I will instruct you that the jury must decide this case based only on their evaluation of the evidence presented at trial, and that they may not base their verdict on anything that wasn't admitted into evidence, and also may not decide this case based on sympathy, prejudice, anger, or any other emotion. All jurors must be able to commit to following these instructions so that they can be fair and impartial and decide this case based only on the evidence we hear and see in the trial. If we do not choose you to serve on the jury, please don't be offended. Sometimes a person who could be a fair juror in one case might have difficulty being fair in another. For example, a potential juror who knows someone involved in a case or has a personal experience that is very similar to the issue raised in a case might have difficulty being completely fair to both sides. So please keep these thoughts in mind as you answer both the written and the oral questions. So jurors, I remind you that there are no right or wrong answers to any of the questions on the questionnaires. And in a moment, the court officers are going to hand out those questionnaires, and I will give you an opportunity, some time to fill out those questionnaires. When you finished filling out the questionnaire, fold it in half and put it somewhere safe. Don't show it to anyone else. Don't share the questions or your thoughts about anything in the questionnaire with anyone else. Doing this questionnaire and answering our questions is a solitary experience. You and you alone. When you safeguard the questionnaire, at some point during the day, you're going to be brought back up to, you're going to be moved to a different courtroom, and you're going to be brought back in smaller groups to go through the individual questioning. Don't show anyone that questionnaire until you hand it to me when you come to the side of the bench and are seated in the witness box, and then I'll take the questionnaire from you. As you also learned during the video this morning, the lawyers play an important role in all aspects of the trial. And with regard to jury selection, the parties have the ability to exercise what we call peremptory challenges. That means that the parties can strike a certain number of jurors in a case. Don't be offended if you're not seated as a juror in the case. We appreciate your sacrifices that you made to be here today. Once we finish our questions, I'll let you know whether you've been seated on the jury or not, and that's the process for today. Fate plays a role in your day today, and by that I mean questionnaires, or the numbers on the questionnaires that I have, start with number 120 and go to number 241. We see people in order of their number. So if your number is closer to 120, you're going to be seen earlier in the day. If it's closer to that 241, later. Whatever your number is, I appreciate, and the parties appreciate, your patience. So, at this time, where are the questionnaires? The court officers are going to pass out the questionnaires. If you need a writing implement, let the court officers know. I'm going to give you an opportunity to fill out those questionnaires now. Jim, do you have a, I left this, I left this uncovered, so I have no, and then I will need the whisper, yeah.
No, it's an internal joke to myself.
It's all dried up. I left it out, unfortunately.
You're looking live inside the courthouse in Dedham, where Brian Walshe's trial was set to get underway today. And if you're just joining us here on CBS News Boston, the breaking news is that he changed his plea. He is pleading guilty to 2 lesser charges: misleading investigators and conveying a dead body. The judge is beginning jury selection, was giving the jurors their questionnaires, which she asked them to fill out as individuals. And then she will ask them those questions as they each come up to be selected. Our attorney, Jennifer Roman, has been with us. And Jennifer, what's the most important thing you want people to know about why and what happened here this morning?
Well, this change of plea by Brian Walshe on those 2 lesser charges really signifies a shift in the defense strategy here. I think what it's saying is that by accepting responsibility for these two lesser charges and pleading guilty, Brian Walsh's team is hoping that the prosecution will allow him to enter a guilty plea on a lesser charge than first-degree murder, such as a second-degree murder charge instead. The benefit to Brian Walsh, if that is in fact what happens, is that he would be eligible for parole. If he's convicted of first-degree murder, he would not be eligible for parole. He would in fact serve a true life sentence. And I think that this pleading of guilty to these two lesser charges is signifying the defense's expectation or hope that the prosecution will come to the table and start to have some discussions with them about him rendering a plea to a lesser charge.
And of course, no certainty on if or when that could happen. Jennifer, realistically, at any point during jury selection? I know Judge Diane Frenier said she wanted to have this jury selected in the next week and a half before Thanksgiving.
Yeah, I think that expecting the juries to be impaneled and a full impanelment by Thanksgiving is ambitious. But we'll see. They have 121 potential jurors there today. So if they are moving along quickly, I guess it's a possibility, but I think it's ambitious. But yes, a change of plea can happen at any time, really. It could even happen in the middle of trial, if that's what made sense for everybody involved. And then if it happened at the point where it's the middle of trial, at any point, a change of plea, the judge has to accept that change of plea and enter it into the docket. So the only thing that would be preventing a change of plea happening is if the judge said she would not accept it, but that's highly unlikely.
You can see what she's going for here. If she wanted the jury by Thanksgiving, she wanted the trial to begin December 1st, the Monday after Thanksgiving. Prosecution has said they expect it to take 3 or 4 weeks. Now you're up against Christmas. And so this is an aggressive schedule. And so she's really hoping this will move along.
Yeah, a lot of hurdles, certainly. And Jennifer, thank you for the insight. Of course, more on CBS News Boston and WBZ News at noon coming up. We do want to get to other breaking news. This from South Yarmouth, where Sky Eye is over the scene of a trench collapse at 152 South Shore Drive. That's the address for the Skipper Chowder House. You can see this is a busy scene. Paula, we do know one worker has been extricated from this trench collapse. Life-saving measures were rendered at the scene, but crews are still looking.
Right. So as you said, the trench collapse happened there. This is Skipper's Restaurant, if you're familiar with the area there in South Yarmouth, and these workers were trapped. The one worker was extricated, and so the public is being asked to avoid that area while the emergency personnel work to secure that area. But as Chris mentioned, you can see the scope of it. Very active scene right now. We want to bring you back to the Brian Walshe trial and look inside the Dedham courthouse. The judge has been very deliberate in telling jurors they were given their questionnaires, which she described as a solitary experience. They fill it out alone and then fold it, keep it with them until they are questioned on the stand, at which point she will look at it as well as the attorneys. These jurors are going to be charged with not watching the news, not researching anything about Brian Walshe, Anna Walshe, or this trial. And so the big change this morning is going to mean some significant changes in the way people view this trial.
Yeah, absolutely. And moving forward, it's going to be imperative whether or not the defense looks to make a plea agreement with the prosecution or not. But they're really kind of juggling two fronts right now. One, once these questionnaires are completed by the jury, to look those over as if a trial were to move forward, or two, to begin the backroom negotiations to see if there's a deal possible with the prosecution. Jennifer Roman has been giving us incredible insight into everything that's been going on in court today. You'll hear more from her over the course of the day on WBZ News as we continue our coverage. Also, WBZ's Penny Commit in the courtroom now, taking notes, making sure she can prepare us for all the things we don't see.
Right. This afternoon, the witness list is
That's
expected to drop. I did think it was so interesting that Jennifer Roman had said, you always hear from attorneys how crucial it is during jury selection to select people who have the right occupations, the right background for the case that's going to be in front of them. She indicated that the defense might be looking for moms, for people who might be divorced, who would understand the nuances of whatever had gone on in the Walshes' relationship, that they probably would not want people who had family members in law enforcement. So this will be an interesting questioning of these jurors as they are put through their paces here with Judge Frenier, and this is expected to go on for several days. The aggressive schedule the judge has set here is she is hoping to have a jury impaneled by next week, by the Thanksgiving break, to begin the trial Monday, December 1st.
And we just want to reiterate for anyone who may be just joining us here, Brian Walshe maintains his not guilty plea on the first-degree murder charge.
Right.
These are two lesser charges that carry significantly lower possible penalties. Lying to investigators, a maximum of 10 years in state prison. Conveying a body or moving a body post-mortem, I believe, is about 3 years in state prison. Jennifer said that the judge will not hand out sentencing today, and that will be handed out presumably at the conclusion of the case, be it at the end of the trial with a verdict, or if a plea is negotiated between the defense and prosecution.
And according to Jennifer, this indicates a shift in strategy for the defense team. Under the statutory rules, no one can plead guilty to first-degree murder. And so by possibly talking to him behind the scenes, looking at this mountain of evidence that it appears that the prosecution has at their disposal, Brian Walshe was probably encouraged by his team to plead guilty to these two lesser charges. If he can reduce that murder charge to a secondary charge, then that preserves his ability to have parole.
Right, and also flipping the coin for the state side, the prosecution side, murder one, there's an automatic appeal. And so if they were to accept a lesser charge, there wouldn't necessarily be the automatic appeal that a murder one charge brings with it. And Paul, of course, the elephant in the room is the specter of the Karen Reed trial that took place in this very courthouse, which was costly, expensive, and left the Norfolk County DA's office battered and bruised.
Yeah, they certainly seem to want to swiftly try to bring this to a conclusion, maybe before Christmas, if this is a 3 or 4 week trial. And, you know, for everyone concerned, jurors are probably, let's be honest, annoyed to be there between the holidays. Yeah. And the judge probably understands that, wants to wrap it up by the time we get to the end of December. We have some sound, I understand, from a little bit earlier. Let's play you some of what was said.
When you are done, you in fact willfully mislead various law enforcement, to include members of the Cohasset Police Department and the Massachusetts State Police, with the intent to impede or interfere with a criminal investigation of Anna Walsh's disappearance.
Yes, Your Honor.
The defendant, Brian Walshe, willfully conveyed away the body of Anna Walshe, or the remains thereof, from the Walshe residence at 516 Chief Justice Cushing Highway in Cohasset by conveying and disposing of Anna Walsh's body without a license or lawful authority, or the remains thereof, into dumpsters and or garbage receptacles in eastern Massachusetts.
And did you do those things or join others in doing those acts?
Yes, Your Honor.
So that was the plea you just heard.
This appears to be a change in strategy on the defense's part, and I think it's a really...
So what you just watched was the actual plea earlier this morning from Brian Walshe, where Judge Diane Frenier accepted his plea. Rather lengthy legalese within that plea. However, those two now are official. He has pleaded guilty to the two lesser charges of lying to investigators and conveying a body, which is moving a body post-mortem. Of course, still on the table, the murder one charge. But as legal analyst Jennifer Roman notes, this could be a strategy, kind of a wedge, Paula.
Right. And what Jennifer wonders is, will the defense shift now and argue that this was an unexpected death? And then Brian Walshe panicked. And that would explain the behavior captured on surveillance video of him at various stores buying particular items, which would indicate that he was trying to get rid of a body. And would the defense try to indicate that was his state of mind? Of course, Brian Walshe was attacked in prison, was stabbed allegedly by another inmate, and there was some question about his mental health about 2 weeks ago, but it was decided by the judge that he was mentally fit to go forward for this trial. So his state of mind is going to be a factor from the beginning of this case right up until the day the trial begins.
A lot of legal mechanisms being pulled by the defense already in these pretrial hearings. One was filing a motion for a site change, but that was denied, so it stays at the Norfolk County Courthouse in Dedham, in which you are looking into the courtroom there. This is very interesting in that resetting the timeline for people here, right? According to Brian Walshe and prosecutors in court paperwork that was filed, the evening of December 31st, 2022, Brian and Anna Walshe hosted a New Year's Eve party at their Cohasset home, at which time Brian said that she relayed to him that she would have to fly to Washington, D.C. on New Year's Day for a work trip. Now, according to Cohasset police, January 1st, early in the morning, becomes the last time Brian claims to have seen her alive. We then have a period of 5 days of Anna Walshe being missing between New Year's Day, early, when she was last seen, and when Cohasset police released a missing persons report.
Right, there was
they were searching for her. About a 5-day lag. Now, Jennifer Roman said, this is not highly unusual for an adult. If it's a child, if it's the elderly, certainly highly suspicious, and that missing persons report is going to go out sooner. But for an adult who claims, through her spouse, that she had a work trip, not so highly initially suspicious.
Right, right. So we're waiting here. The judge is, I gather, watching the jurors filling out their questionnaires. The attorneys will begin questioning them, selecting them. And again, the whole nature of this trial has shifted this morning. WBZ's Penny Commit is inside the courtroom. She'll be reporting for us throughout the entire trial, starting on WBZ News mornings and throughout the day. And here on CBS News Boston, we're going to take a quick break. We'll be back with more coverage after this.
Couple more. Okay. All right. So the court officers have told me we're set, and if you haven't finished filling it out, and I think everyone has, but if you haven't, you're going to be seated downstairs in another courtroom for a bit of time. So at this point, court officers are going to move everyone but the first group, right? Sure. Down to the first floor to courtroom number 10. Again, I'm going to remind you of a couple of things. First, you cannot talk to anyone by any mechanism. No texting, phone calls, no emails, no nothing. Tweets, nothing. Keep your phones off during the time of jury selection. Second, don't speak to each other about anything while you're down there. Again, task of being selected or being chosen as a juror is a solitary task until you come in and you get questioned by us. So I appreciate your patience, and we'll see you all, depending on your number, in a little bit or later in the day. Thank you very much, jurors.
Step up right this way, please. Make sure you take all your belongings.